The key point, I guess, that it's important to know is that trademark registrations are territorial. So just because you've got a trademark registration in New Zealand doesn't mean you've got registered trademark rights overseas. To get registered trademark rights in different countries, you've got to apply through their trademark systems, just like you have to come through ours. A useful strategy is, say they want to go to Australia, you know, our main trading partner right next door, and they also were thinking down the track they might want to hit Europe as they expanded. But it can be expensive to register your trademark in each country. So there are different sort of tools or different approaches you can take. Now, New Zealand and just about every Western country, or just about every country actually, in fact, these days, are a signatory to a particular treaty, which means that if you file a trademark in New Zealand, from the filing date of your New Zealand trademark, you have 6 months that you could file in these other countries, and you can claim what's called convention priority from your New Zealand application. Now, in effect, what that means is, instead of getting the date that you file, say, we'll use the example of Australia, say we file in New Zealand, then 4 months later we file in Australia. When we file in Australia 4 months later, we can claim the New Zealand filing date, so 4 months before we actually file in Australia. Trademark registration is a bit like a flag in the sand. Whoever gets their flag in the sand first generally has the trumping right. So it buys you a bit of time, so you can file in New Zealand, sort of see how it goes a bit in Australia, and if it begins to look promising, then you can then subsequently file into Australia and claiming convention priority. But in each case there, you have a separate application. These days you can do what's called a European Community Trademark application. It's known as the CTM. Now that one application covers all the European member states. Now the advantage of doing that is, with one application you get all those countries if you subsequently, you know, if your application proceeds to registration. So it's a lot cheaper. If they're using a similar trademark, sort of knocking off a copy, so to speak, say you're in the clothing business and they're using a similar brand to yours, and you've got a Chinese trademark registration, what can you do? Well, you have to basically go to China and protect your trademark through the Chinese courts using Chinese law. You know, there's no other way around that. Trademarks are like any type of private property right. It's up to the owner to enforce them. Once you have your trademark registrations, they're a private property right, and as the owner you must go out there and enforce them.